Hey, welcome back to the second half of the lesson for week 1. This comes out of chapter 3 in the Arnheim and Prentice. I keep saying Arnheim and Prentice, in the Prentice textbook. Arnheim has since passed, so if you hear me saying that, he was the original author of the textbook. The current author was the second author, and he has subsequently taken the first author's name off. So at any rate, out of your textbook, chapter 3, legal concerns and insurance issues for the athletic trainer. Now, we live in a society where people love to sue, and healthcare is certainly one of those areas that is very frequently a part of that. So as an athletic trainer, there are a number of things we need to be aware of in order to protect ourselves and to protect our patients and to protect our workplaces. Athletic trainers and coaches are held accountable, and rightly so, for the care that they deliver to their patients. So because of some of the things we do, things like spine boarding, a patient with a suspected cervical fracture, or any number of medical procedures that we do, and not to mention cases of sudden cardiac death or other tragic occurrences in athletics where we are potentially exposed to legal liability, and in those cases they're looking to prove negligence on the part of the athletic trainer. So we're going to look at that today. First of all, liability is the state of being legally responsible for the harm that one person causes to another. So typically speaking, in a lawsuit against an athletic trainer or any healthcare professional for that matter, the person bringing the suit, the plaintiff, has to prove that the individual they're suing, the defendant, is directly responsible for the harm caused to them. Now, it's rare that athletic trainers are going to be tried in criminal cases. More likely it's going to be a civil case where there's dollars associated with it. But in cases of gross negligence or other types of ethical breaches, there could potentially be criminal charges brought too. But it's the plaintiff's responsibility to link their harm to the defendant, and that proves that they're liable. Now, the way they do that is through, first of all, establishing what the standard of reasonable care is. And that standard is established by looking at someone with your same level of credentials or qualifications and proving that either the athletic trainer didn't do what they should have done, in which case they committed an act of omission, or they did do something they shouldn't have done. In a case of if they didn't do something, that's omission. If they did do something, it's commission. So the standard of reasonable care assumes that a person is of ordinary and reasonable prudence or judgment. And we have to be thoughtful and careful relative to the situation, any extenuating circumstances. And we have to operate within the limitations of our background. So unless an athletic trainer is operating, unless they have an additional certification, if all you have is an athletic training certification, it's not within your scope of practice in any state to administer IV fluids or to reduce a dislocation. And if you do those things, then you could be found negligent. That's beyond our scope of care. Now, a tort is a legal wrong that's committed against a person, and this can result from nonfeasance, where a person fails to perform a legal duty. In the state of Texas, there's now legislation that dictates how an athlete with a concussion is dealt with. So if we don't submit that athlete for treatment, for care, for evaluation, then that could potentially be non-feasance. We didn't do what we should have done. Malfeasance, on the other hand, is when we do something that we shouldn't do, like we already talked about. We do an IV, or we reduce a dislocation or a fracture. And misfeasance is we do what we are allowed to do, but we do it wrong. Okay? Misfeasance would be we're doing spine board and something goes horribly wrong and we drop the patient. Okay, we were doing something that's within our scope of practice to do, we just didn't do it correctly. Now, to prove negligence, the plaintiff will have to show that direct linkage between what the athletic trainer was duty-bound to do and what was done. So, in most cases, an athletic trainer working for a school or a college, they have a legal obligation to provide service. Now, let's say you are out, say you're a certified athletic trainer and you're out in the community watching your kid's baseball game and someone gets hurt and you start to render care. Now, in that situation, you don't have an obligation. You probably fall under Good Samaritan laws in that case. But once you start to render care, you have an obligation to provide care. You can't just quit midstream. And you'll talk about that oftentimes in first aid courses, patient abandonment and things of that sort. So, as an athletic trainer at an institution, you have a duty to provide care to that person. And sovereign immunity speaks to state employees. A government entity can't be held liable for negligence, and that does vary from state to state, but if you see that term thrown around, that's what it means. It means you're an employee of the state, and as such you can't be sued for rendering care in that line of action. Now, that Good Samaritan law provides some protection against legal liability in the event that you're rendering care that you're not duty-bound to provide. You're at the mall and someone collapses and you deliver CPR. You will be covered under Good Samaritan laws in most cases. Now, there are statutes of limitations. How long can an athlete or a patient wait until they bring suit? It does vary, but generally it's in the neighborhood of 5 years. So if you've got a patient who's a senior in high school, 10 years later they can't sue you and say you didn't care for them properly, so now they've got arthritis. The clock begins at the time the negligent act takes place and continues on following that negligent act. Now, in some instances, minors may have a longer statute of limitation. It may take longer for some of these issues to crop up because of growth and maturation. Now, if you're working in a traditional setting and you are working with actual athletes, or if you're in a non-traditional setting and you're working with employees, either way, they will probably have an assumption of risk waiver that they sign. And here's where the person is made aware of the risks that are involved with playing football or working as a tire builder or whatever. That is expressed in written form, and they will typically have to sign that in order to be eligible to participate. This can be used as defense against an individual's negligence suit. We can say, you signed the waiver saying that you understood that playing college baseball could result in injury. It did. If we told you about it, you assumed that risk anyway, so that's on you. That may or may not hold up in a court of law, but it's good practice. It's considered standard practice, in fact, for us to require that of our patients. Now, just because they've signed that assumption of risk doesn't mean that they're excused from, or it doesn't mean that we're excused, rather, from giving them that reasonable care and using appropriate professional judgment for what we do. There may be instances where that assumption of risk will not stand in cases of fraud or misrepresentation or duress, where we, if for whatever reason that assumption of risk was misrepresented as some other form of documentation. Now, in order to reduce our chances of being sued, there are a number of things we can do here. We can, first of all, just try to develop and establish goodwill. Okay, so working to establish good working relationships with our patients, with their parents, with their co-workers, with our sports medicine team. We want established written policies regarding our athletic training facility and our coverage. We need an emergency action plan, and that needs to be venue specific. So whether we have a baseball field or a field house or a basketball arena or a clinic, all of those need to have action plans in place ahead of time. We also need a thorough medical history of the patients under our care, and adequate documentation is an absolute must. And then lastly, a job description that details what we will and won't do. Obtaining written consent relative to providing care, this usually comes in the form of a physicals packet where the patient and or their parent, depending on their age, sign consent saying it's okay for you to treat my child or okay for you to treat me. We maintain confidentiality through those HIPAA regulations. Medication distribution and modality use can be, in particular medication distribution can be a real landmine for some facilities, so that's worth giving a closer look to. How do we hand out over the counter? Do we handle prescription medications for our physicians and that kind of thing? So there are a number of things we can do here. Another one is not allowing athletes to return to play until they've been signed off by a physician, and that's actually something that Texas has done with their concussion legislation. It ensures a patient seen by a medical professional before they're allowed to return to play. We also want to make sure we follow physician's orders to the letter, especially when it has to deal with participation. Okay, if we let them go too soon, they feel great, but it was pretty clear that they were under the physician's care for another week. We're exposing ourselves to the risk of a lawsuit. Liability insurance is another way we can reduce the chance of lawsuit being placed against. It's not so much protecting us from the lawsuit, but it protects us in the event that a lawsuit is brought. And anybody can sue you, whether they have grounds for it or not, but that liability insurance can be beneficial. We got to know our scope of practice. That does vary from state to state, so reading the State Practice Act and knowing what we are legally authorized to do and what not to do is important. I know when I was in Arizona, we made custom fit mouth guards for our entire football team and at the U of A. And in order to do that, we had to have dental impressions. And at that time, in the state of Arizona, it could have changed by now, I don't know. But at that time, it was legal for us as athletic trainers to do dental impressions and pour molds and make mouth guards. And this was actually a way that I thought, these things are very expensive. If you have them made, they're $250, $300 at a dentist. There's actually only about $5 worth of material in the mold and in the mouth guard. So my thinking when I moved and went into a typical 40-hour-a-week job was I would start a business and I would make mouth guards for athletes. And when I started to look into it in the state of Illinois, that was actually considered practicing dentistry without a license. So I pretty rapidly scrapped those plans and got rid of any ideas about starting a mouth guard business because I wasn't able to do that in the state of Illinois. And it's also worthwhile just to use common sense. Okay? Posting our policies and procedures, just being wise in our dealings is going to reduce our chance of being sued. All right, next up is product liability. This is another legal area for athletic trainers. The reason this comes up is we may have to make or fabricate a custom pad or splint or brace, or there may be cause for us to modify an off-the-shelf piece of equipment or splint or brace. Now, liability for any and all parties involved in a manufactured product. Anytime you purchase a product, there is product liability built into that. If you bought a football helmet, for instance, or Riddell, whatever specific type of football helmet, part of the purchase price you're paying is for the product liability that the Riddell Corporation pays for that product. Okay. Now, if that product has an inherent defect, let's say the shells crack on a new model of helmet, that the end user could bring a lawsuit and sue Riddell. Now, typically what's going to happen there, especially if this is the first they've heard of this, is they're going to examine the equipment and make sure it has been modified. Okay, so product liability is based on negligence, strict liability, and breach of warranty fitness. So the manufacturer will almost always put a warning label right on the shell of the helmet, or if it's protective equipment, on the protective equipment. And this is almost like we talked about with an informed consent. I used to laugh because when I walked into the gym for the first time at U of A, every piece of equipment has the word death written right on it. And I said, that's pretty clearly a sign to me that I'll never be a gymnast. There's a lot of risk involved in the sport. Now, most of our athletic equipment, helmets in particular, will have this NOC-ACIL, National Operating Committee on Standards for Athletic Equipment. And these are minimum standards. These are tested just like you've probably seen videos of automobile manufacturers crashing cars for crash tests. There is standardized testing for football helmets, baseball, softball helmets, hockey helmets. And unless a piece of equipment has this seal on it, then it's safe to say that it doesn't meet their standard. It hasn't been tested or it didn't pass. Now, initially, this will probably be cast into the shell. It's actually a raised area on the plastic. But those also need to be inspected and reconditioned annually, in which case they'll get a renewal sticker. Now, as athletic trainers, or maybe you don't have any intention of being an athletic trainer, but you intend to be a coach, we shouldn't alter equipment. And that may be tempting to do sometimes. It may be a real easy fix. So what you see here is this is a concussion cap, and you can tell by the picture this is an old photo. This is from the mid-90s. A couple of NFL players tried these, and this is just basically a foam cover that went over the helmet. And it attached, I think it velcroed in place. But the product liability of that Riddell helmet did not include any type of additional equipment added to it. In some instances, even paint. If you added a paint, it could actually alter the chemical properties of the shell and make it more brittle. So even something as simple as having the shells painted, you want to make sure that's done by a reputable reconditioner, because that will ensure that the helmet certification isn't invalidated. Because if you do, let's say you took it upon yourself, I'm going to save my school district money, I'm going to paint these helmets, or we see this sometimes. Instead of this 4-point chin strap, we've got a 4-point low, and we need to drill a hole here for a snap or a buckle. Even drilling one hole invalidates that product liability warranty, and instead of Riddell paying for it if something goes wrong, you pay for it if something goes wrong. And we don't want that, so we don't modify equipment. So we'll shift gears a little bit and go to general health insurance. Insurance can be confusing for sure, and knowing how to navigate this is honestly a very challenging part of the job for a lot of athletic trainers. So general health insurance is a policy that covers everything. If you're in college, you're typically still eligible for your parents' insurance up to usually the age of 22. It may be offered through the institution. If you don't have insurance through your parents, you can get insurance for your student health through that. Secondary insurance is what athletics departments usually pay, and that will pick up whatever your parents' insurance doesn't cover, the secondary policy through the institution will pay for. But either way, a school and institution has to ensure with an E, that individuals have insurance with an I, because we understand that there's likely to be medical costs associated with participation. Accidents do happen. So accident insurance is super cheap. This is a low cost plan that covers an accident on school grounds or in the workplace. This can be in place just to protect you in the event of a catastrophic loss. This may cover costs associated with hospital care, with surgery, catastrophic injuries. I had to utilize this when I was first out of college. I played on a Athletes in Action basketball team that toured New Zealand and Fiji. And I was the athletic trainer / forward, believe it or not. I played and was the athletic trainer. And the last day of our camp, we were practicing, getting ready to leave that next day. I was in the middle of practice, and I took an elbow to the face and broke my nose. Now, at the time, I was fresh out of college. My job hadn't even started yet at Arizona. My wife and I had just gotten married, so we didn't have any insurance. And AIA required us to purchase accident insurance. It was like $50 for the month of the tour. And that $50 policy saved me, I think it was in excess of $8,000, because I had to be taken to the hospital, I had x-rays, I had to have a number of procedures done there, IV, and all kinds of things. Stitches, seen by a couple of different physicians. So this can be cheap insurance. It doesn't cover a whole lot, but as long as that accident occurs when and where it is covering you for, then it can certainly save you a lot of money in the event of an accident. Catastrophic insurance, these injuries aren't really common in athletics, but obviously they're tragic, and the psychological toll is tremendous. But there's also a pretty staggering financial toll as well. So the NCAA, the NAIA, the NFSHS, which is the National Federation of State High Schools, provides, hang on a second. Sorry, I had to look that up for a second. NFSHS, I was correct on the definition there. These are intended to provide extra coverage not to the athletes but to the institutions that may have to be responsible for lifetime extensive care. So this could be a tremendous cost. So although it's rare that this would be utilized, having it in place can save a tremendous amount. Professional liability insurance is for the caregiver, for the athletic trainer. Most employees will have insurance that protects them from damages that arise from injuries that occur on the institution's property while that individual is performing the duties of their job. Personal professional liability insurance would cover you in the event that you're doing something other than that. If you're helping your kid's little league team, or you're covering a high school on a Friday night just to make a little bit of extra money. So this is really important. The professional liability insurance that the institution purchases is frankly in place to protect the institution. It's not in place to protect the professional. So having it for yourself ensures that you're covered, and it's not very expensive, a couple $100 a year at the most. Now, last time we talked about third-party reimbursement. That really doesn't apply to athletic trainers just yet. We are working on it, but this is how most medical services in the U.S. are paid for. So if you say you tear your ACL, before you're ever seen by anyone, in most cases, if you're just Joe Public, you're on campus, you trip and fall and you tear your ACL, you've got to be seen by your primary care physician first. They are going to determine whether or not you need a referral, and chances are they're going to refer you to an orthopedic surgeon. At which point, the primary care physician will charge you a copay, whatever your insurance says, if it's $20 or $40 or whatever, and then they'll bill the insurance company for the rest. That could be a couple $100 if they do x-rays, and it might be more than that. So that third-party reimbursement, the third party is the insurance. The patient and the insurance company are the first two parties. The third party is the provider. Okay? So that provider, as a physician, can be reimbursed by the insurance company for the services that they render. Okay? When you go to the orthopedist, there's another copay that you have to pay, and they'll bill your insurance company, and they get reimbursed. Now, there are a number of different prearranged systems, and the reason you had to see your primary care physician first is because orthopedic surgeons bill more. So the insurance company wants to protect themselves from you going straight to the most expensive option first. So they use that primary care physician as a gatekeeper. And if you don't need to be seen, then you're not seen. Okay? Now, most insurance companies are starting to pay a little bit more for preventative care. So if you get a wellness screening, or a blood panel drawn, or some places will even pay you to work out or provide incentives for you to join your company's incentivized fitness program. So there are other systems in place other than just after-the-fact payment. Now, one of those prearranged care options is the HMO, and this will provide some preventative measures, and this does dictate very specifically where you can receive care. These pay pretty well. It can reduce your out-of-pocket expenses as long as you operate within the confines of that health maintenance organization. You've got to get a referral ahead of time, except in an emergency, and if you wanted to see a different physician and they're not in network, then you're going to have to pay for that out of pocket many times, or you're going to pay out of network prices, which are considerably higher. If care is rendered within that HMO, then oftentimes that HMO will pay 100% of the costs. So if we've got an athlete in an HMO and we send them to a provider outside of it, what we have to understand is that means our secondary insurance is going to have to pick up the tab for all of that. And it won't take long of that occurring before our policy premium goes up. So with each passing year, we have to pay more and more to get secondary insurance for our patients. A PPO, on the other hand, provides a discount for health care, and they do limit where treatment can be obtained. We have to be aware of what facilities are approved. This is usually a much larger network than with our HMO, so you have more options, but with more options comes more cost. There may be other types of coverage available here. So a lot of times something like an HMO you may consider like a VA hospital to be an HMO model, whereas a PPO, you could go to physicians within the community provided they are in network, and you'll pay a fee for service. So I just had an MRI this week on my knee. I had to pay a copay to my primary care physician and be seen by her. I was then referred to an orthopedist. I had to pay a copay to him, was seen by him, and then I had to go for the MRI and pay another copay there to have the procedure done. He just read me the results over the phone. I know what I need to do, but if I were in a position where I had to go back, every time I go back I have to pay that copay in the office, so it can get expensive. In the case of a student athlete, even those copays, those are going to be picked up by the secondary insurance or paid for out of pocket by the athletics department. The athlete themselves won't have to pay that. Now, point of service plan is kind of a hybrid between the two, so not as many options as a PPO, not as much coverage as the HMO, but it does allow for some movement outside of the plan. In all honesty, if I were to look at my insurance, this is probably more of a point of service model. There may be some flexibility for certain conditions. Let's say you've got a child and there's only one pediatric neurologist for 700 miles and they're not in network. Then you can sometimes make a phone call and see if you can get that allowed, but not always, and you can't guarantee that. Another alternative is an exclusive provider organization. This is restrictive in numbers, much like an HMO, and this is almost like emergency insurance. If you're out vacationing, traveling, you're probably not going to be in your network, so these won't pay anything. A physician hospital organization, this involves the major hospital or chain and its physicians. So for instance, if you had one with University Medical Center, there's not a lot that you can't get within that organization. PHOs contract directly with the employees to provide services. Here's the interesting thing is my son was in the ER. I can see the ER from my office, but the physician who rendered care for him wasn't in network, so we had to change physicians for his follow-up care. So even though I'm an employee at the Health Sciences Center and UMC is physically attached to the building, we don't use a PHO model, so that UMC physician couldn't see my son if I wanted it to be covered under insurance. So that can add some frustration for the athletic trainer when we're trying to figure out where we want to send our athletes to keep the costs for everybody involved as little as possible. Now, a third-party administrator is used to administer services. Claims for these group plans They function kind of as a pseudo insurance company. They'll do enrollment and billing, and like I said, almost with the other plans, this helps control utilization, and we make sure that people aren't going to see specialists that they don't need to see, because usually, even though we don't think of healthcare like a consumer, there very much is a supply and demand phenomenon. In fact, if there's only one physician in a huge geographical area, then they can command higher prices, and oftentimes the insurance company won't pay that difference. Medicare is another option. We don't usually think about that with a young athletic population, but most people age qualify for these benefits. There are two parts. Medicare Part A is the hospital portion, and then Medicare Part B is the physician portion. But honestly, despite all the different levels of athletic training I've worked in, I've never dealt with Medicare restrictions, so I guess that's good. Same thing with Medicaid. Medicaid is health insurance for people with low income, limited resources. Individual states administer Medicaid. Those benefits do vary by state. Some of the athletic trainers I know that deal with Medicaid patients find that it's probably just easier to submit everything to secondary and not mess with trying to file those claims. They just don't have the time to do it. Workman's compensation, this does vary by state. I never thought I'd deal with this. Honestly, when I started out, I figured I'd be in college and high school settings. But something I never considered is when I work with professional athletes, whether that was minor league baseball, arena football, NFL, those individuals' jobs were sport. And if they're injured, then they're entitled to workman's compensation. So for instance, when I worked in the Arena League, we had a weekly call with our league's workman's compensation insurance coordinator so that we could figure out who was eligible for benefits in that given week. If they were not able to play, then their paycheck came from the league instead of from the team. And as you can imagine, in some instances, that is a significant amount of money. The employer pays the premium, and then the claims are settled by workman's comp insurance carriers. So their goal is to get the worker back to work as soon as possible so that they're not carrying that salary. So you may, I was never questioned by the group that we worked with, but understandably they didn't want anyone sitting on that injured list longer than they had to be. Now, as we said before, third-party reimbursement is a challenge for athletic trainers. We've been able to bill third parties, but most insurance companies won't reimburse for those. Third-party payers may view the licensed healthcare professional as reimbursable. In most states, though, we're not able to use the athletic training codes. Those won't be reimbursed. The way around this is those services are billable as a PT aid, AIDE. Physical therapist assistant is an associate's degree in most places, and that practice as an assistant or aide isn't regulated the same way physical therapy is, or athletic training for that matter. So an athletic trainer can render aid to the PT, but unless you have a PT in that clinic, you obviously can't aid someone who's not there. So not many clinics operate with only athletic trainers in them because they need those PTs to sign off on that reimbursable task that was done. And this is why the NATA has been staunch in trying to get this pushed through, because if third-party reimbursement could be approved, then you would see clinician-owned practices strictly with athletic trainers, so that an athlete off the street, maybe they don't have an athletic trainer at their high school, they go to the clinic, they're seen by the athletic trainer, that patient's insurance company would pay for services. You could do that now, but insurance won't pay, so that means you're operating on a cash service only. And also keep in mind what we said before, is that athletic trainers always work under the direction of a physician. So you'd also have to have a medical director involved. So you don't see a lot of those private practices now, simply because there isn't the cash flow available in order for that to be a viable business model in most places. So the NATA is working on trying to get this pushed through. Honestly, I held out a lot of hope that this would happen at one point. I really don't know that this will ever happen for us. Maybe that's just me being pessimistic. But whether it does or not, I think we would do better to focus on the jobs that we do have and to be the best we can be at those. Nobody can deliver care to collegiate athletes better than athletic trainers. Nobody can deliver care in the day-to-day operations. I mean, nobody's better suited for that role than we are. Professional sports too. We've seen a big influx, especially in like the NBA, in sports scientists, and in particular an influx of people from different models, different backgrounds, who have essentially taken the jobs of athletic trainers. And that's unfortunate, because I think our skill set is the best for that setting. So instead of going out to chase dollars from patients that were never really part of our core anyway, and this is just me on my soapbox, I think we'd be better served to focus on what we already have and do it best. All right, so that kind of wraps that up. There are a couple other slides here you're welcome to read through, but honestly, I'm looking forward to getting into the thicker meat of the course, if you will. Paperwork and insurance have never been, and usually aren't, the reason why athletic trainers get into the profession. We get into it to help people. So we will start talking about some patient care next time. So until then, keep up. Make sure you are following along in the syllabus and getting your assignments done. Read ahead, and I will see you next week. Have a great day, and I will see you then.